landlords still have the decision of who they accept or don't accept in terms of the tenant coming in. So if they really don't want someone in, they can just say no and decline the offer. They don't have
Yeah,
to
absolutely.
accept any physical offer. So
Yes.
they're not being sort of held over a barrel for these things. It's up to them to make the decision on the tenant that they choose. So these are new
Yes.
legislations coming into place to sort of open up the market a bit and make it a bit more easier to transact. But ultimately, the decision of who lives in your property and as the landlord is still down to you. You make the final call and have to accept that offer or not.
Yeah, because as you can see, the wording is reasonable grounds for objection, but at the end of the day, it doesn't say you have to accept. Yeah, that's absolutely correct. Decent home standards. I'm going to just breeze through this part because there hasn't been any specific updates on this part. But at the end of the day, like I said last time in our last video, whenever landlords go through reputable agents, there is probably, I'm even going to say generally, there shouldn't be any standard issues because every unit that's managed by an agency has an allocated property manager, and they are the communication person or channel between the landlords and the tenant. Any issues are always raised in this manner. So, I mean, at the end of the day, I say to landlords, we are probably more inclined to want to get it fixed than not, because at the end of the day, we don't want tenants to make a complaint and then give them a reason to call for compensation and withhold rent, right? So a lot of the times, once an issue raised, it's straight away communicated to the landlord. This is how much the call out will be. This is, this is the issue the tenants raised, and the aim would be to fix on site, unless parts need to be ordered, etc. Yeah. Prohibition of discrimination. So still applies, obviously, to tenants on benefits, tenants with children, and I suppose, pets would be one also, if you want to put it all in one category. But again, as Ludo mentioned, ultimately landlords has the final say in who they want to have in their flat. I think some of the points on the renters' right bill, it's kind of, it's been said, but again, there's not much weight in how much it can be enforced at the end of the day. So ban on rent bidding. So we would actually rarely see this nowadays. The marketing wording of offers in excess of. This actually applies more for a sales transaction. So in sales listing, we will see two types of listings. So actual price, so maybe 500,000, that would be the price, or it could be in offers in excess of 500,000. All this is really to stop any kind of bidding going on. So, if the market rent was supposed to be 2,500 a month for a flat, what government don't want is, because there's this bidding war going on, all of a sudden this flat's now completely priced out of what the market should be for that kind of flat in that area. Okay, rental arrears repossession. So currently, we can speed up repossession for a flat that's in rental arrears. So once a flat reached 2 months or more rental arrears, we can serve something called the Section 8 notice, giving the tenant 2 weeks notice before. What the Renters' Right Bill is proposing is to increase that notice period from 2 to 4 weeks and wait for the rental arrears to go from 2 to 3 months. So essentially 4 months in rental arrears before we can start the speed up repossession. What we can do to, I suppose, counter the risk or exposure that this brings is having a rent and legal eviction insurance in place. So I've probably forever that I've been in this industry doing lettings, I've always said to clients, buy a rental legal eviction insurance. I mean, I personally buy it for my investment flats also.
How much are
It's
we talking? Give us a rough ballpark figure.
So it's a range because with the Renters' Right Bill in mind coming into play, and there may be, just slightly increase in potential claims happening, insurance partners that we work with now actually got rid of the ballpark figure, which was a huge rental range for one figure. So now they tier it based on what the rental is monthly. Or so basically it starts from as low as 350 to about 520, but we're covering a large rental range. So we're covering rental range from 1,500 all the way to 5,000 plus. to give you an idea. But once we know what the rental is for that client, we will give them that specific premium for the year. So the rental legal eviction insurance covers two parts, as the name suggests: the rent. So once we've established the tenant actually has no intention, or they're really struggling to cover the rent for whatever reason, we can make that claim, and the full rent will be paid a month in arrears to the claiming landlord. But usually when tenants are in rental arrears or financial difficulty, they probably are also waiting to get onto some sort of government housing, and they probably need a bailiff notice. And in this instance, they do need to go through eviction. So the landlord needs to evict the tenant in order for that bailiff notice to be available. So the legal eviction part of the insurance will cover landlords for costs such as legal fees, employing a solicitor, their court attendance on your behalf, etc. Yeah, so definitely buy it. I've always suggested clients to buy it even before tenant fee ban, even before now the renters' right bill. So end of rent in advance. So there is talks of upfront banning or abolishing upfront payments as part of the renters' right bill. However, the debate does acknowledge that currently there are existing tenancies that are running on an upfront payment kind of schedule, right? Whether students or people that might have just immigrated to UK and they don't have that financial check available yet, they may be paying 6 to 12 months in advance. So Amendment 44 allows for the continuation of these tenancies that are already on this model or on this type of payment schedule, even if once the bill comes into play, that tenancy goes into a renewal, as long as this was agreed prior to the bill coming into play, becoming legislation. And there's no need for landlords to switch from upfront payment to monthly on the implementation of the Renters' Right Bill. So they can continue, and that is covered by Amendment 44. Now, there hasn't been talks around whether there is a possibility where mutual parties agree to create that same kind of tenancy. There might be further talks of this, but at least on this time around, there wasn't any mention of that. They only talked about or referred to existing tenancies. They did also talk about professional guarantors, because if a tenant type, so the tenant type that cannot pay monthly are students, and as I said, tenants that might have a good amount of savings, but they might, currently not have a job, for example. So how professional guarantors work. So sorry, let's go back. So with these tenants, if they want to pay monthly currently, they can, as long as they get a guarantor. But a guarantor in the UK means that they are a homeowner and also they are, working in the UK. So sometimes tenants can't get that. And the introduction of professional guarantors are basically companies that, for a small fee, again, the fee has not been clarified. And I did get asked a question of who would be paying that fee. My assumption would be the tenants, because it's the tenants that requires the service. The companies will then act on behalf of the tenant as a professional guarantor. So should they have that in place, then it will allow them to go from upfront payment to monthly, but with security to the landlords. Okay, so there were talks about mandatory registration of landlords on a central database. And should any landlords not comply, like I said before at the beginning of the video, any rogue landlords that don't play by the rule, they're not registered on a database, they jeopardize their right basically to terminate a tenancy unless they're on that central database. And what does the central database, really trying to achieve is basically, where landlords have been rogue, or they haven't, there's been disrepair in the flat, they've not dealt with it, they've been not really good landlords, they would probably be, now we can blacklist these landlords on the central database. So as I said, it's trying to create a nice, safe, secure environment for tenants' rights. And as part of that would be to get rid of or drive these type of landlords away from the industry. Now, in the last debate, there wasn't really much distinction mentioned between student lets and other types of tenants, or student tenants and other types of tenants. there were proposals to keep fixed tenancy for certain student lets, for example, student HMOs, but during the debate, that idea was rejected. Again, I think further debate would be due on this point. There wasn't actually much spoken of in terms of how students' lets would be handled, because they are very different types of let from a professional and a company. So moving forward, as I said, we are talking about or presenting the points that were discussed before the consideration amendments that did happen 8th September. So after of which the royal assent should be received and the bill will become legislation. And they are looking to have the royal assent by the end of the month, and they're trying to implement the bill into legislation early next year, early 2026. But as I mentioned before, there will have to be a lot of secondary legislations coming into play and a lot of clarifications on certain points before this can really come into play, because you can see there were gaps as we went through the whole presentation of, okay, there needs to be further debate on this. There needs to be further clarity on this. So yes, but that's what the time frame the government is aiming for the bill to be implemented early 2026. Yeah, so do you have any questions or any points you want to ask?
No questions, but points wise, no, all good. I think from my point and the way that I view it is there's probably in the press been a lot of scaremongering towards landlords about what some of the changes are. Ultimately, the way I view it is if you're a good landlord and do things with a professional agency managing your property and have insurance and do everything the right way, then this will barely impact you at all in terms of the changes. If anything, you might actually benefit from it, because I do foresee this actually increasing rents in the short term. So you might actually get a kicker in terms of what you're getting on your rental income. But we will be back for take 3 once everything's come through, and we can update everyone with sort of the outcomes of where we're at with the bill and what physically has gone into law and what can and can't be done. So Edith, thank you as always. We will keep everyone updated. I will link everyone's details in here, and then if anyone's got any questions, reach out to either one of us. But thank you.
Thank you.